Hey, good morning, everybody. This is John, and welcome to Exploring Week 4. So time's definitely flying by, and we're really starting to get into the meat of the course in terms of legal analysis, in terms of analyzing the iTriality case, and so it's pretty exciting. And I appreciate everyone's engagement. This is definitely the most engaged class that I've taught. I think I mentioned that before, but I definitely appreciate it. I think it adds a lot of value to the class. For those participating and responding, also just reading through comments, I think it adds a lot of value in terms of what everyone gets out of the class. So I appreciate that. Anyways, we're officially in fall. The mornings in Colorado are starting to get a little brisk, even though I think it's supposed to get close to 80 today. So I've got the sweater vest on today. It is a little chilly in the morning. We are talking a little bit more about medical records this week, and I think the discussion question. This is definitely my favorite discussion question of all of them, only because it really forces you to think about how to think about a situation critically and how to conduct a proper legal analysis. So, first, with respect to medical records, I think all of you are familiar with HIPAA as it pertains to protected health information in the medical space. HIPAA can be broken down into three different rules, really: the privacy rule, security rule, and enforcement rule. The enforcement rule is just how the Office of Civil Rights, which is the arm of the Department of Health and Human Services that enforces HIPAA. Basically, the enforcement rule is essentially the authority that they have and the actions that they can take in terms of enforcing the other two rules. So, privacy rule, just as the name indicates, governs how a covered entity handles the privacy of protected health information. Security rule is just how the administrative, technical, physical safeguards that a covered entity has to have in place in order to properly protect protected health information data. So, with respect to medical records, one thing I wanted to focus on really is our patients' rights, particularly with respect to access to medical records. I think the interesting thing to me in terms of the privacy rule is there's no situation, very few situations in which it requires in fact, I don't think there's any situation in which it requires a covered entity or provider to disclose protected health information to another provider or health plan, for example. There are rules in which they're prohibited from doing so, and there are rules in which they are permitted to do so. But there isn't really necessarily any situation in which they're required to do so, as it pertains to other providers and health plans. I think what's very commonly known is a patient's right to access their own healthcare records. So, you as a patient or your personal representative have the right to access your healthcare records. They have the ability to charge reasonable rates that's governed by HIPAA, and typically there's a state law that covers the rates that a provider is allowed to charge for access to healthcare records. I think you're familiar with the right to amend healthcare records and to make corrections. If a provider or plan doesn't agree with your request, you have the right to submit a statement of disagreement with the provider, and they have to add it to your record. So there are a variety of I think important aspects to the privacy rule as it pertains to patient rights. Which is what it was designed to do, and a lot of state privacy rules are designed to do the same thing. Now, speaking of other laws, there are a lot of other laws that govern medical records. It's not just HIPAA. So, as I alluded to a little bit ago, every state has their own medical records laws. Typically, they have laws related to record retention. So, HIPAA does not necessarily have a rule related to the length of time that a provider or covered entity is required to retain medical records, but that's governed by state law. So some state laws will say 6 years, some will say 10 years, some will say 10 years plus, if it's a minor patient, plus the age of majority, or 10 years from the last visit date, 15 years in some states. So it'll vary from state to state. Some states have notification requirements. So if medical records are being moved, so if maybe a medical practice is merging with a hospital, or if a medical group is going out of business, they still, even post closing their business, they still have responsibilities with respect to retention of medical records. For example, I represented a medical group that had entered into a joint venture with another medical group for a sleep center. Well, they dissolved that sleep center, and as part of the dissolution, we had to figure out, okay, how are we going to handle the retention of medical records? So this is kind of a different case, because it had been open for quite some time, where they had some paper records, they had some electronic records, and so we had to come to this agreement in terms of who's going to be responsible for the storage, the maintenance, and the costs of retrieval if a patient requests those medical records for both the paper record side and the electronic record side. And then so you come to this agreement, put together a medical record custodial agreement that outlines who's responsible for what and who's responsible for what cost. So anyway, so with that, there's in some states, in a lot of states, there's notification requirement. You're required to notify those patients that are affected where their medical records are stored, how, who do they contact, how do they get access to those records if they need to. And a lot of times, some states, I know in Kansas where I used to practice, you're also required to notify the state health department. So they have that on file as well. If a patient calls them up and asks about that, then they can do so. So those are important. State privacy laws, it's really important. And, there are other medical record laws and rules in other, regulatory schemes, like Medicare has its own, not necessarily not necessarily record retention rules, but medical documentation rules for sure. Medicaid, same thing. So there are a lot of rules and regulations, statutes, laws, both on the federal and state level, that govern the documentation that's required to be in medical records, but also patient access, record retention, and things like that. Now, the interaction between HIPAA and state law is really interesting. So essentially, in some cases, HIPAA may preempt state law, which all that means is that HIPAA may, if there's a conflict between state and federal law, then federal law can preempt or basically take over and be the controlling law. And that's generally the rule with HIPAA. HIPAA can preempt state law. The only exception to that is if the state law is more stringent. So meaning if it's more strict or more rigid, then it's a more rigid requirement than what HIPAA requires, then state law will control. So anyways, that's kind of how they get. Outside of that, HIPAA essentially controls if there's a conflict between the two laws. So finally, I just want to talk a little bit about the discussion question this week. Like I said, it's my favorite question. That you're presented with a couple of different scenarios, and then you're asked essentially if there was a breach. And so I think for a lot of people, that if you don't do a lot of legal analysis or think about these situations from a critical analytics standpoint, then it's very easy to say, okay, you look at the fact scenario, and you kind of go with your gut reaction. Okay, yeah, that seems like it's a breach. So the question I would ask is, what is a breach? And I think the question is definitely the key question is, what is a breach? How do you define a breach? Is, for example, if if I'm a nurse or a doctor or any sort of practitioner, I'm at a hospital and I accidentally drop a paper chart on the floor, and another patient walks by and sees the name on the chart. Is that a breach? Or if I leave it on my desk, someone comes into my office and sees it laying there on my desk, is that a breach? So, I mean, is any time an inadvertent use or disclosure, or any sort of any use or disclosure that's not related to the treatment of the patient for that's used or disclosed to somebody else, is that a breach? Well, there is a definition of breach, and I'm going to post the link to that in the announcement when I post this video link. So I think it's really important to look at that definition. The definition of breach itself requires its own analysis. There are a variety of factors to consider. There are exceptions to what may constitute a breach. So it kind of goes back to what we've been sort of emphasizing throughout the last few weeks, which is that IRAC form of legal analysis. What is the issue? What is the rule? In this case, rule is, what is the definition of breach? Because the question is, what is the breach? Well, in order to answer what is the breach, you have to know what breach means. Then do your application, apply the rule to the facts, cite specific facts from the discussion questions, analyze it, and then come up with your conclusion. So I've said this before, but I'm not concerned about, like, there's no right or wrong answer to me. I mean, clearly in certain situations there are definitely wrong answers, but I'm not so hyped up on the answer. I'm hyped up on the analysis. So if you go through that, what's the issue? What's the rule? Apply that rule to the specific facts. Do your analysis. Come up with a logical conclusion. If you appropriately apply the rule to specific facts, and it's reasonable, your analysis is reasonable, there's no doubt in my mind that you'll come up with a reasonable conclusion. And so that's all I'm asking for. So anyways, of course, as always, if you have any questions, please reach out. I am around, not traveling this week, so I should be able to respond pretty quickly, and happy to help in any way that I can. Anyways, hope you have a great and productive week. Take care. Bye.